You want to make me a call so I can let people in?
No, I can keep an eye on it.
Okay.
So I can't share my screen here because I have tried to find a way. I've done searches for the slides, and the slides were only available on the app. So this is I'm started the recording, folks. We're going to do a deep dive into the rest of the legal panel for UAR 2023. So if you weren't able to attend the convention down in St. George, what was it, 2 weeks ago? Now, or was it last week? I don't know. It's all a blur. But if you weren't able to attend, we're going to go over some of those things. And prepared to be terrified and affrighted. That's one of my, sorry, that comes from the scriptures. They were terrified and affrighted and supposed they'd seen a spirit. That's kind of the way everybody in the room felt after this legal panel. So I don't know if you guys got a chance to see, I know Rebecca saw the video that I did on the what was it? Seller financing. That's something that's new. We've never faced that before, where interest rates have tripled in a matter of months and banks are going out of business. And so for the first time in my 20 years, they actually have a strong motivation to exercise that due on sell clause, which they've never had before. And we've got investors out there that are saying, oh, I've done hundreds of these and never had one of these exercise. Well, they are now. So can't say that, and you have to correctly advise your clients. And what we're saying in regards to that is tell your clients to talk to an attorney. Because they have potentially some pretty serious consequences. And one of the things we're looking at here at Equity is a disclosure that is a little bit more attention grabbing than what we have available on the forums. So stay tuned for that, because when we see a problem, we like to be proactive. Just like I had an agent email this morning saying, hey, what is this seller disclosure confirmation form that's required? Well, that's a form that protects the sellers from their client saying, well, my agent told me I didn't need to disclose that the well water was contaminated from Camp Lejeune, and that kind of stuff. So agents become a convenient target when attorneys get involved. And even when it's a family member, the attorneys can say, hey, you're facing this $50,000 lawsuit, but if you had this conversation with your agent and then they didn't disclose it, then we can shift all the focus over onto them. And even though it's your family member, don't feel bad. They've got E&O insurance. Doesn't work that way. Okay. So that's why knowing these details is important. That's why I appreciate you guys watching this video or attending here live. The first thing that we're going to talk about, I did a little legal scenario that went to the Supreme Court. I posted that video last week. Today, we're going to start out with the EPA audits. I don't know if you guys have seen these, but this is something that a lot of agents are not doing correctly. And so everybody kind of needs to stand up and take notice. I've encouraged, I met with all of our brokers in the state last week and told them, get out there and start training your agents. So the EPA has been sending notices. I'm reading off of my app, by the way, the slides. So the EPA has been sending notices of imminent inspections for compliance with the lead disclosure rules. Came 2 weeks before the audit. It required a list of all residential transactions over the last 3 years, including housing type and age. The inspection could include up to 10 individual contracts, penalties up to $19,507 per violation. So about $20,000 a pop. Inspection could be 10 individual contracts. That's, if I do the quick math there, $195,000. That's crazy, right? So everybody should be sitting up and taking notice. And you're probably sitting there thinking, well, I do everything just fine, right? Lead-based paint disclosure, by the way, quick quiz. House has to be how old? I got a house built in 1979. Do I need a lead-based paint disclosure?
No.
No. I got a house built in 1978. Do I need a lead-based paint disclosure?
No.
Yes.
That's where we get it. Rebecca, you said no. Why?
Because it's before 78.
Prior to 78. Now, I've had underwriters say, hey, this home was built in 78. We've got to have this lead-based paint disclosure. The law reads prior to, but try arguing with an underwriter. if you want an exercise in futility. So there is some question marks out there. People don't know, but Rebecca, you're correct. It's prior to 78. But listen to this. So this is the lead-based paint disclosure, the seller's responsibilities. Before ratification of a contract for housing, sell, or lease, sellers and landlords must disclose known lead-based paint and hazards and provide available reports to buyers or renters. Now, this is in our lead-based paint disclosure form, right? But this is before ratification. So that means before we've got an accepted contract, we're supposed to have this. And what we see a lot, and actually the attorneys brought this up, is that in Utah, one of them said that they kind of remembered over the last few years, and Rebecca, you might remember this, that they made this a part of the seller's disclosures because we have in our contract the ability to cancel for any reason without penalty prior to seller disclosures. So we do need to have that disclosed upfront. Here's the one that gets you. Sellers and landlords must give buyers and renters the pamphlet, Protect Your Family from Lead in Your Home. How many of you are doing that? And how many of you have proof of doing that? You're giving out the pamphlet. You're not just giving out the lead-based paint disclosure.
Is a email, does it have to be the actual physical pamphlet?
No, I think if you're doing an email with the link, then you're okay.
I email the pamphlet.
That's what I do.
Okay, good. If you're doing that, then we want some record of it. Okay. So we are looking at creating a lead-based paint disclosure with a link to the pamphlet in there. And that would be nice, right? So we'll see if we can get something like that put together. But we do need to not just be giving the disclosure, we need to be giving the lead-based paint pamphlet as well. And then of course, home buyers can get a 10-day period to do an inspection if they want to. And we got to keep that for 3 years. So what's my responsibility as an agent? Ensure that sellers and landlords are aware of their obligations, proper disclosures, signatures, and the warning pamphlet. And they've got that warning pamphlet underlined and emboldened because that's where people are getting hit is, did you provide the warning pamphlet?
Eric?
Yes.
You know that on the MLS, we have to provide that and we have to stipulate that that's what it is. And sometimes people put it in there and it's not filled out. And then, so that brought this up to me. I don't send that to the people again. I don't send that to my buyers again, not my buyers, but well, I don't send that again to a buyer if I'm a listing agent. Do I need to send that again through .loop? Is that a best practice maybe? I don't know if that made any sense. I'm rambling.
It did. The argument is whether or not just having it posted as a optional download, I guess, on the MLS. If the challenge would be, so here's my thought on that is, what's defensible in court? And then if you take one step further back from that, is there a way that we can make it where we don't have to defend ourselves? Because I do think that's probably defensible, saying, hey, we had it in there as the uploaded documents. You could have accessed it any time. But are we making that argument in court? And if we have something that was sent in .loop with a date and timestamp saying, no, we did send it to you. It wasn't just there available for you to get on your own. We did send it to you, which meets our obligations here. Then I think we avoid even the possibility of having that argument, if that makes sense. So for me, best practice would be having something that is very clearly date and time stamped, which .loop does for us, saying, yes, it was sent. Here's the date. Here's the time. Here's the proof of it.
Okay. So, but do we need to send it before we accept an offer? I mean, or do you think it's okay to send it after? Maybe I'm overthinking this, but it's kind of got me a little bit worried.
So again, this is one thing I would probably need to research, because even the attorneys on the panel didn't look like they were totally certain of this. But I thought that Utah had changed that requirement in the law to, Jake, do you want to do a little bit of searching while we're doing this? Google that. But I thought that Utah had changed that requirement that we could make this a disclosure, not just prior to acceptance, but if it was done by that disclosure deadline, because our contract allows a buyer to back out without any penalty by that disclosure deadline. So I'll have Jake Google that a little bit while we're doing it. But the key thing here that they found that agents are missing is we're doing the lead-based paint disclosure because our MLS helps it with it. It makes it required if you're posting the listing, like you said. And Rebecca, even though it is required to post it, if it were me, I would say best practice is to still send it over in .loop so that we can very clearly point to a date and time stamp of when it was sent to them. And then making sure that warning pamphlet is included. So other things that agents have to do, make sure that there is an opportunity to do inspections if somebody wants to do that. And this applies to leases as well as sales contracts. And then, of course, we keep records for at least 3 years. So the forms that we have, the disclosure acknowledgement regarding lead-based paint and the lead-based paint addendum, failure to comply. What if the seller or landlord fails to comply? The agent is responsible if the seller or landlord fails to comply. However, an agent is not responsible for information withheld by the seller or lessor. So if the seller and agent fail to comply, it does not invalidate leasing and sales contracts, but there are very steep penalties possible of triple damages, potential civil and criminal penalties. Jake, did you find anything on your search?
Not yet. I'm still reading through it.
Okay. If you find something, let me know. We're going to move on to AI. Isn't AI fun? Jake, you're using AI?
Love it.
Yeah. AI is fun. You get to go around and play with it. Have you guys all been on ChatGPT just for fun to check it out? So we've got AI built into KV Core. You know, somebody clicks on your website, they get an automatic response. Say, hey, I noticed you're checking out my website. Is there anything else you'd like to get? You know, every holiday that rolls out, we have some automated messages being sent out. This is an emerging issue, and there are some unknowns with it, but there are a few known things. Here's a funny story. So this attorney in Manhattan used ChatGPT to help him write his pleadings in a personal injury case. ChatGPT wrote the response, creating fake cases, fake quotes, and fake citations. This guy thought that it was like a Google search and it was just finding stuff for him. No, it made it all up. Okay. And so the attorney was pretty humiliated with that. He didn't comprehend that it could fabricate things like that. So AI is being used drafting emails and replies to customers, forming business plans, chatbots, making images, personalizing advertising, automating messages, social media posts, autofilling MLS forms, matching properties and clients. So it's being used in lots of different ways. When using AI, here's some of the best practices. Educate yourself and your teams. It says don't input personal info. I honestly don't know why they didn't go into detail on that, because it can kind of get everything. Here is the big one. Review everything for accuracy. Check facts and proofread, because AI makes stuff up. That's what it does. So you got to check facts. You got to proofread. You got to make sure it's that. And then don't use it as a substitute for a competent attorney. So drafting contracts and addendum or providing legal advice. We cannot do this. So state law says that we have to use forms that are approved already for use, or we can use an attorney to draft forms, but we cannot use AI to draft forms. So don't be convinced that that's a good idea. And then one of the big ones is copyright issues. AI product may not be protected. So if we're creating content using AI, who's got the copyright to that content? Is it the people that created ChatGPT, since they created the content? Since it was created based on other things, could there be a potential copyright violation there with other things? So those are evolving issues that we don't have a lot of answers to yet. But the bottom line with AI is double check what it's giving you, because it may not be factual. Okay, so be careful with that kind of thing. There was a separate class on AI that it was really sobering. It wasn't meant to be scary. It was meant to say, hey, these are the things that it can do. And it can do a lot of stuff, you guys. It can take your voice and copy your voice. It's being used by scammers. People are using it legitimately for their business as well. But you know, your dear old mother could get a call from you with your voice saying, hey, Mom, I'm in trouble and help me out. And it's your voice that an AI captured and generated. So there are some crazy things out there that you just want to be aware of. They did talk a lot about fraud, not necessarily in this, but with AI, it kind of ties into it. Be really careful about clicking on links. Okay. Be very wary of that kind of stuff. Have two-factor authentication set up for everything, for your emails especially. Wire fraud has been a very serious issue. All right, one of the next issues I want to talk about really quick came from Bad Belke. He's the CEO and past attorney for the MLS. So the big issues that we're facing now is, and we talked about this a little bit, there's the more moral versus NAR. Realogy Holdings Corp., now Anywhere Services or Anywhere Real Estate, Home Services of America, RE/MAX, and Keller Williams. This was, I believe, a $4 billion lawsuit. And then there's another one, Sitzer Burnett versus NAR Realogy, which is now Anywhere, Home Services of America, RE/MAX, Keller Williams. And that one is for $13 billion, but they say it could go up to $40 billion. Okay, that's with a B. So here is some of the primary allegations of the plaintiffs are this. They allege that NAR and the broker defendants conspire to require home sellers to pay the broker representing the buyer of their homes and to pay at an inflated amount in violation of federal antitrust law. So they're saying, hey, you know, they sent out that same letter, just like they did with, you know, have you drank the waters of Camp Lejeune? That same thing's going out to everybody in the state saying any sellers that sold their home over the last few years, you may be entitled to damages. So everybody jumps on. That's how they get these huge numbers out there, right? They allege that NAR's adoption and implementation of a mandatory rule that requires all brokers to make a blanket, non-negotiable offer of buyer broker compensation when listing a property on the MLS caused the inflation of prices. So a blanket, non-negotiable offer of buyer broker compensation. Now, we know that that's not true, right? Everything's negotiable. We're negotiating commissions almost as much as we're negotiating sales prices and stuff, but that's their argument. Okay. They allege that in a competitive market, buyers should pay the buyer broker's fees. And that's insane, right? These people are so out of touch with buyers today, paying 7.5% interest rate. They're paying their closing costs. They've got their down payment that they've got to come up with. And now they're going to have to pay their own buyer's agent's fees as well. And they definitely need a buyer's agent. I don't know how many of you over the last few years, you know, when the market was really hot, how many of you would entertain offers? If you had 20 offers, how many of you would entertain offers from somebody that was unrepresented? We didn't even entertain them. We talked to my clients and I'm like, these guys, they don't know what they're doing. They're going to run their inspection. They're going to, every little bump they hit, they don't know how to fix it. These aren't serious buyers, you know, and I'm not trying to be anti-competitive or anything like that. My job is to disclose facts to my clients, and every unrepresented buyer, when they hit a bump and they don't have somebody walking them through how to fix the issue, They get scared and they leave. Buying a home is a scary process. So buyers need agents. Agents can provide a lot of value. Do they all provide a lot of value? No, some of them suck. Okay. But it's not us because we're here learning. So, anyways, they're alleging that in a competitive market, the buyer would pay their own commission. They allege that sellers are incentivized to offer a high commission, so agents will show their houses. Will you guys show a house if it's offered a BAC of 3%? Yes? Brian, raise your hand, damn it. Okay, Jake? All right, Rebecca's not showing her screen, but I know she will. What if that same person offered 1% BAC? Would you show the home?
Yes.
Yeah, Brian? Jake? Brian's froze, it looks like. Okay, his answer is yes. What if they offered $1 BAC? Would you show the home? The answer is yes. Why? Because it's all negotiable. Even if they offered 0. Now, in the past, I will tell you that they've been required to offer something. That's why we see $1 on there occasionally. I was told last week, because one of our brokers is on the MLS board of directors, and he said that they've now made it so that you can offer 0. You can offer 0 as a BAC. Now, listing agents can offer that 0. We're the buyer's agent. We show up to the house, 0's there. Well, we know this before because we've pulled it up on the MLS. We tell our clients about it. How do we navigate this world? If we've got a 0 BAC, a $1 BAC, a 1% BAC, we handle it all the same. How do we handle it? We've already established we don't withhold that home from our clients, the buyers, right? We're the buyer's agents. We have a fiduciary duty to show them everything, right? So we're going to show them the home regardless of what is offered. But what else is happening? I'll just tell you, the suspense is killing me. Okay, here's what's going to happen is we met with our clients a month ago. When we very first started this process, we met with them and we did a buyer presentation, correct? Everybody nods their heads affirmatively. We did a buyer presentation, even if it was our mother, even if it was our sister. We didn't necessarily have to do a presentation to win their business because they love us. We did a presentation anyways. We did our buyer presentation the minute they started talking about wanting to buy a home. We did not take them out and show them homes first. We did not wait until we were making an offer to do a buyer presentation. We did a buyer presentation right up front. And we told them all of the great value that we provide because it is so much more than simply driving around and opening up homes. We're not Uber drivers and we're not the magic key holders. Okay. We're experienced negotiators. We know hundreds of legal forms because we study our forms, and we know the process. We know how lenders work. We know how to write the contract so that it works within the rules of lenders. We know things to include, things to not include. We know the deadlines. We know the people that we need to engage to make those deadlines happen, the different professionals that are going to be involved. We know how our buyers can be protected. We know how much earnest money they should be putting down to be competitive and at the same time protect their interests. We know all of these things. And we have this communication, we have this talk as a part of our buyer's presentation. And because we had this talk, we can show them everything out there. They're hiring us because they understand our real value. And so now we send them a list of homes and we say, oh, by the way, you'll notice, or they may not notice because sometimes this isn't shown on some of the reports that we give, but this home here, they're not offering a buyer agent compensation. And so you guys remember our conversation that we had way back in the beginning, that typically I am compensated by the listing brokerage. In this case, I would not be. So we would need to negotiate that. I would need you guys to have my back because we're going to negotiate for that commission if that's the home that you guys decide that you love. All right. And we can negotiate that in a couple of ways. I can call up the listing brokerage and say, hey, I noticed you offered 0 BAC. Would you sign a brokerage commission agreement for 3%? And they'll say, you know what? The seller chose not to offer anything. Okay, that's fine. So we're not going to get it from the brokerage. We tried, we didn't get it. So now we go back to our buyers and say, hey, this home that you loved, they're not offering a commission. So we're going to need to negotiate that as part of this deal. Or you can pay me directly if you want to. And we did have a few, at the height of the market, 2021, first part of 2022, we did have some buyers choosing to pay that commission to make their offers more aggressive and more competitive. But in a typical market, they don't need to at market value. So we have the discussion with our buyers and they say, you know what? Yeah, I would like to negotiate and have them satisfy my obligation for this buyer agent commission, because we don't work for free. We signed the buyer agent commission, the exclusive buyer broker agreement right up front when we had our buyer presentation. We communicated our value. They said, yes, I want you on my team. And we said, here's my fee, 3%, 2%, whatever you negotiate. We put our fee down there on that paper. And now fast forward a month or two down the road, we're out shopping. And we can have this conversation and say, okay, I've talked to the listing brokerage. They're not offering a buyer agent commission. So we had this discussion a month ago. This is one of those cases where if we like this house, if this is the house that you want to offer on, then we're going to use the brokerage payment addendum form. Y'all know where that form is? It's the brokerage payment addendum that says, in addition to any funds being offered by the listing brokerage, the seller is going to pay this. So it works great. If the listing brokerage is offering $1 or the listing brokerage is offering 1%, and our contract with our buyers is for 3% commission, then we can use the brokerage payment addendum and say, hey, seller, you're going to satisfy the other 2% that your brokerage isn't paying. Okay. And it's right there, part of the offer. The buyers are negotiating with the sellers to help satisfy their obligation in their exclusive buyer broker agreement. All right. So we already have the forms there. Now, here's the thing that will possibly surprise you. In a lot of states, they don't have an exclusive buyer broker agreement. It doesn't exist for them. And because of that, some of these problems come up because buyers agents were not having this conversation. They were not communicating their value. They didn't have a brokerage agreement in place saying that I do work and I don't work for free. I do get paid this amount. And so here in Utah, we are significantly protected with that. And it is negotiable. So here's NAR's position on these cases. First of all, the MLSs provide unprecedented competition, allowing for a variety of commission models. And that's absolutely true. Okay, there's a lot of different variety out there in what you get offered as a compensation through the MLS. Compiling house information is accessible to all businesses in one place, allows smaller real estate brokerages to compete with larger ones. And that's true. So it helps with competition. A small mom and pop shop has access to all the MLS listings that the big ones do because of the MLS. And these arguments are saying that the MLS is anti-competitive. All right. Access to inventory and widespread advertising, along with the practice of the listing broker paying the buyer's broker's compensation, incentivizes local broker participation. And that's true as well. When we put this all out there and brokerages are saying, hey, I will help satisfy your obligation to pay your buyer's agents if you'll come and show this home, that encourages participation. It encourages brokerages to work together rather than discouraging competition. It encourages it. And the MLS creates the largest opportunity for connections between real estate agents with properties to sell and those with clients looking to buy. And so that's the official position. One of the challenges is that Anywhere, which was Realogy, has already agreed to settle for $83.5 million. Okay, it says the monetary settlement was the most that could be obtained in light of Anywhere's available financial resources. So what does this mean if they've already agreed to settle for $83 million in one of these? Potentially, it could be lots of copycat lawsuits. you know, because, you know, attorneys are taking a big chunk of that, right? So if they could make 30% of 83 million, that's a pretty large incentive to just go out and try to sue everybody. So some of the best practices that we have are using our forms correctly. We need to be having that buyer meeting with our buyers where we sit down and communicate our value to buyers and have an exclusive buyer broker agreement signed up front. That's part of our defense. Another part of our defense is last year we updated our forms. And so our exclusive right to sell agreement shows the seller, I'm charging, you know, a 6% commission or 5% commission. And in return, I'm going to offer a 3% buyer agent commission or a 2.5% buyer agent commission, whatever it is. And the seller initials that section where it says we're offering this much of a BAC. So we've already seen some forms change to help with this, okay? Anyways, those are big issues that could potentially change how real estate is already changing things. We're already seeing updated forms. We're seeing the MLS offering 0 compensation. Before they offered $1. Now they can actually offer 0. But it should not be changing a lot how we do business, because we should always have been doing a buyer presentation. We should have always been getting a buyer broker agreement signed up front. And we should always be communicating our value. All right. Copyright law. This one was crazy, guys. Okay. Y'all seen those funny memes that you can copy and share? Do you have a right to those? Can you take those? Can you change them up? Okay. These are questions that you get to ask. Here's a fun one. Court orders small brokerage to pay $28.8 million for copyright infringement after the brokerage distributed marketing materials without the proper attribution. So this was in Texas. It was against a small brokerage. They were using building plans, architectural drawings, blueprints, in marketing of their homes. The architectural firm said that they didn't have the license to use it in the manner it was being done. The brokerage lost, and similar lawsuit regarding home floor plans is going to be heard by the Supreme Court. So just because we have plans doesn't mean that we have the right to publish them. So let's talk about all of these different ways that you can be hit for copyrights. Actually, I'm going to read you a couple of more little ones. Zillow had a little $2 million lawsuit. Let's see here. Here's one that the attorney on the panel got. Demand letter claiming $30,000 in damages for a photo that was on a brokerage website for 1 day. $30,000 in damages. Photographer and law firms have businesses designed to trick you into violating their copyright. So what they do is they'll make a photo like a stock photo, and you know it's free to use, but it's free to use one time or on 1 day or something like that. And so then I don't know if they have code embedded into that photo, but when it's being used anywhere else, immediately they're on it. They've got attorneys' forms already drafted, ready to go, with potentially $30,000 in damages for having it on a website in 1 day. And the attorney said that they looked at it, it had been seen like 26 times, and 22 of them was by attorneys and staff. He says, I don't think the public even saw it one time. So how do we avoid this kind of thing? First of all, if you're using photos that aren't yours, okay, you didn't personally take them and you didn't hire the photographer. Maybe you're listing a home in the winter and your client says, I've got some great pictures of the garden during the summer. Say, great, send them over. Okay. One of the things you can do is get something in writing from the client saying, these were my personal photos and you have permission to use them. Okay. If they got these photos from anywhere else, then we need to get, so for example, if they send us blueprints, we need to have it in writing that we have permission to use those blueprints for marketing purposes, right? That's probably not something that came with their blueprints. That's probably a separate permission. So the rule of thumb here is you either take your own photos or you hire them to be taken. And if you didn't do that, then you need to get written permission to use them. Now, what about your photographer? Does your photographer that you're using give you permission to use the photos for marketing purposes? And this may be something that is going to evolve the photography industry for real estate. We even have agents that hire out and do photography for other agents. We should be getting a letter from them saying, or if you're hiring Tour Factory, that's one of my favorite tour companies. Does their contract give me the right to use those photos indefinitely? Okay. This is something that we want to be aware of, and we want to get something in writing saying, if we hired those photographs to be taken, if we hired that out, we need to make sure that we have in our license agreement to use those photos for marketing purposes for as much as we want. So if you're using a photographer, make sure that they're giving you some kind of a statement like that. And this may be something that causes them to evolve their businesses as well. So it says, even if you use stock photos, make sure they're still licensed the next time you want to use them. Because that's one of the things they're doing, is they're allowing you to use it for a day, a week, a month, and then they're not. Then it's not free to use anymore. And there's code embedded in there to trick you. So that's a fun one, isn't it? Makes everybody sit back a little bit, pay attention. All right, here's one. I want to advertise another broker's listing on social media. Can I do it? What's required?
Written permission.
Written permission from who?
Well, that's where I get fuzzy. Is it from the broker and the agent, or do we need it from the seller too?
State law. This is 2F 401B, prohibited conduct as applicable to licensed individuals. An individual licensee may not advertise or offer to sell or lease property without the written consent of 1, the owner of the property, and 2, if the property is currently listed, the listing broker. The owner and the listing broker. Okay, how many of us are doing that? Now, what if we share our IDX feed, our website? Are we okay with that? If it's IDX, if it's our website, it's IDX compliant, meaning that it's pulling stuff directly from the MLS. Are we okay to share an IDX feed?
Yes, because the listing, when you put the listing up, you agree to have it used on the IDX feed, right?
Yeah. So we're okay with the IDX feed. But if I want to do some kind of marketing that isn't that, then I need to get separate permission. Here's one of the things that we're seeing a lot nowadays, because we're all becoming social media stars. How many times do you go online and you see a funny picture of a house? Just saw this on a listing today. What do you guys think? And maybe they say, this was awesome. I saw this amazing home today. What did you guys think of this? Or they say, like, give me your favorite meme for where this toilet is located, or something like that, right? We've all seen those things, haven't we? Buyers agents that are going through making those funny posts, whether it's a funny post or it's a complimentary post, do buyers agents have permission to be taking photos or recording inside of that seller's home? What do you say?
I say no. The buyer can use them for their own reference, but they can't use them any other way, is the way I understand it.
Okay. Can a buyer take their own pictures in a home?
I think they can, as long as you let them know. They can't post that on social media until it's their house, right?
So this is a separate issue about the buyers, but I would even say if buyers are going to be taking pictures, they should have permission. This is not, it is private property. It's not public property. And even though they're being invited in for the sake of buying it, they should probably get permission before they're taking pictures, and because they could be taking pictures and they could be making funny memes out of it as well. And none of those things are allowed. Okay, this is somebody's private home space. So the law is specifically talking about licensees. Licensees can't do it without the written consent of the owner and the broker if it's listed. So we shouldn't be recording things. We shouldn't be making our funny memes. We shouldn't be doing that unless we're the listing agent. Eric, yeah.
So I remember a couple of years ago, actually, when we were selling our own home, an agent came in with his cell phone and just did a walkthrough, recording the whole thing for his client that lived in another state.
Mm-hmm.
So I guess this falls into that same category.
Yep, that would fall under this. That's a perfect example of where you would want to do it, but you would want to get written consent. Okay, so how do you get written consent of the seller, the owner of the property? Well, if you're the buyer's agent, you got to do that walkthrough. You say, hey, law says I need written consent of the owner of the property and the listing broker. Could you please get that for me? And if the broker says, yep, I talked to my clients, they're good to go, and we've got that in writing in an email, I would think you're probably fine. Okay. There isn't any form for it. And I think we could act under good faith if we say, hey, we need the owner's permission. Can you ask the owners? And they say, yeah, we did ask the owners and you're good to go. Go ahead and record there. Okay, this is one that came up last year where it was being mistakenly taught that if you did any marketing, you had to have the brokerage name and the branch name in all of your marketing. And you don't have to have the branch name. You can if you want to, but you have to have the brokerage name. So our brokerage name is Equity Real Estate. Okay, it's not Equity Real Estate North Branch. Some of you have been with me for a long time. We're just Equity Real Estate. All right. If you have a team name, you can share that as well, but the brokerage name still has to be present. Okay, a team, group, or other marketing entity which includes one or more licensees shall be subject to the same requirements and restrictions with regard to advertising as an individual licensee. So the name of the brokerage identified by a licensee in an advertisement shall be the name of the brokerage as shown on division records. So that's Equity Real Estate. Okay. All right. And yeah, the different examples that they're giving on here are the rule that it has to be one click away. Let's see. They're actually having a new proposed advertising rule. These would clarify things a little bit more. In an electronic advertisement, a licensee shall clearly and conspicuously identify the name of the brokerage with which the licensee is affiliated, or ensure that the advertisement directly links to a display that clearly and conspicuously identifies the name of the brokerage. So what size of font do we have to use?
Doesn't matter as long as it's conspicuous.
Clear and conspicuous. It used to be, it had to be 50% the size. And so I still get a lot of agents that say it has to be 50% the size of the largest font. That's the old rule. But then they had agents out there measuring stuff and saying, look, clearly they're off by a millimeter. You should fine them. And it was just stupid stuff. So they actually changed the law to make it more vague, clear and conspicuous. The name of the brokerage identified by a licensee in an advertisement shall be the name of the brokerage as shown on division records. A licensee may also include in the advertisement the name of their branch, their team, their group, or other marketing entity. Okay, so those are the proposed changes.
So Eric,
Yeah.
So you know how you said about you're not supposed to put Equity North Branch or anything like that. But if you put equity, you could put Equity Real Estate North Branch, and that would be fine because it still says Equity Real Estate in the name, right?
Yeah, but North Branch doesn't exist anymore. So that was the name of my office before I became principal broker. When you're principal broker, you don't get to have any nicknames. It just has to be the official name of the brokerage.
But if you make your team, you know, Equity Real Estate A team, you can put that in there as long as it says Equity Real Estate in there somewhere.
Yeah.
In your, even if it's in your name, it's fine.
Yeah.
Okay.
Okay. Let's talk about TCs. Okay. If you need a license or not. Licensed transaction coordinator can do anything a licensee can do for their own brokerage. Unlicensed can perform unlicensed activities only for any brokerage. Okay, so if you're hiring a transaction coordinator and they are unlicensed, they can do unlicensed activity for any brokerage. They can only get paid a predetermined amount, not contingent on the transaction closing, and not a portion of the commission. So if you hire a TC, you have to pay them whether the deal closes or not. Okay, otherwise it's an illegal sharing of commission. All right, the hybrid is a licensed assistant performing non-licensee activities. So if you're a licensed assistant, can you perform non-licensed activities for a brokerage other than yours? You're a licensed TC. Can you do unlicensed activities for a brokerage other than yours? So the examples given by the attorney. Can you arrange flowers for a brokerage other than yours? Yes. Can you wash the company cars for a brokerage other than yours? Yes. Can you clean the toilets for a brokerage other than yours? Yes. Those are all unlicensed activities. Can you perform non-licensee activities for a brokerage other than yours? Yes, but the same rules that apply to unlicensed assistants apply to licensed assistants. Essentially, they're not a licensed assistant when working for a different brokerage. Here's the concern, though. So I brought this up to our Utah brokers, and one of them is one of the commissioners. And the commissioner says, well, there's another concern, too, that wasn't mentioned by the attorney here, which is this expectation of confidentiality. So now I'm hiring a licensed TC. He is only doing unlicensed activities, but he's still licensed with a brokerage that isn't my brokerage, and he now has access to confidential information. So this expectation of confidentiality, which is inherent part of our fiduciary duty, is being violated. So we've provided to our transaction coordinator a contract where even if they're licensed or not, it doesn't matter. They're only doing unlicensed activities. And there's an addendum that they have the other brokerage sign where they're disclosing, I'm using an assistant that is licensed with another brokerage. They're only going to be doing unlicensed activities, but you're aware of this. Okay. So that was the other thing that was covered by attorneys. And that was the last topic that they brought up, is talking about TCs doing work inside the brokerage or outside the brokerage. If it's outside the brokerage, as long as it's unlicensed, you can do it. But again, for the expectation of confidentiality, I think you need an addendum to the listing agreement saying we're going to be sharing this information with staff that is not within our brokerage. Okay. If you are doing work within your brokerage, then you're okay. You know, so it is much safer to be using a TC within your brokerage. But even if they're licensed, I still recommend that they be doing unlicensed activity. You shouldn't be having your TC preparing addenda for you. It's one thing if you're going to be out of state, they are licensed. Like we've got one of our agents in Africa for a couple of weeks, right? So if you've got a licensed TC and they work for your brokerage, then they could potentially draw up an addendum for you because they're licensed. They're able to do that, right? They could prepare it for signatures. They could do all of that stuff. But by and large, The agent should be the one doing those things. They're the ones directly tied to the client. They should be aware of the contracts. And there's stories of agents that are completely oblivious to what's going on with their contracts. They're just expecting the TC, sometimes an unlicensed TC, to be doing all of that stuff for them. So having a TC does not absolve you of your responsibility to be a good agent. You need to be the one involved. You need to be the one preparing the contracts, doing that kind of stuff. TC helps you stay organized, helps you with your communication to everybody, but they're not replacing you or your value. So are we clear on all that stuff? Okay, there's our summary. Any questions, you guys? No? All right, I'll stop the recording.